Welcome to Channel 17, the Town of Colonie Government Channel.
Hello and welcome to the Money Factor. Today's topic is workers' compensation. It's a complicated subject, but I think we have a guest who can help us out. Stephen Carbone, our guest, has worked for 20 years with the Workers' Compensation Board. He's head of the agency's policy and planning area, the budget office, and served as a business ambassador and advocate for the workers' compensation system. He's currently serving employers, employees, insurers, and government agencies in the board's Bureau of Compliance as his head of the Bureau's Educational Outreach Office, and that's probably why he's here today. Recently, he was the chief author and editor of the board's Employer's Handbook, and that implies that he has a lot of information because he's had to go through the whole thing and set it up. So I'm really happy to welcome back Stephen Carbone.
Richard, it's a pleasure being here.
Thank you. We've got a lot to cover today. I've written down a lot of questions because, as you said, this is not easy.
It's not easy, and unfortunately a lot of people get very confused, and there's a lot of misinformation out here, which is why we're here today, is to try and eliminate some of the confusion at least.
Great. Now, I always like to start out with the real basic. Sometimes I think it's a stupid question, and then I find out maybe it's not so stupid. What is workers' compensation? What are we compensated for?
Well, it's a social insurance program. It came about all the way back in 1914 in New York State as a mandatory insurance coverage. 1914? 14. Yeah, it goes all the way back. And the reason why they put it into place is to protect injured workers when they're hurt working on the job. And it was, again, we live in a very political state. So, no shock there. So it's a political process. Labor does get benefits. Labor, in terms of you get your medical care provided for, and you also get, compensation for the time that you can't work, and employers get benefits too.
And people have families, so even if they have health insurance, and their medical expenses are paid, somebody has to eat.
And in many cases, if you get hurt and you're injured on the job, you go to the doctor or to the emergency room. One of the first questions that they're going to ask you is, where did the injury occur? Why are they interested in asking that question? Because as soon as you utter the words, it's a job-related accident or injury, or they get the accident report and you were in a company truck or car and you were injured at that time, then all of a sudden red flags go off and it becomes a workers' compensation claim. And in many cases, even if you say, oh, my health carrier is going to take care of this, the health carrier can controvert and say, hey, wait a second, it goes to workers' comp. Workers' comp is your insurance of first recourse, which means that if you're hurt on the job and you need medical care, it becomes part of the workers' compensation process.
Now, you must speak to a number of groups. You very willing, you were on this show once before.
Yes.
What kind of people are really interested in this? Because to me, it seemed like something that nobody thinks about, and I didn't think about it, and then the opportunity to have you on the show came up, and I was thinking about it suddenly. But what kind of people actually ask you about it?
Well, employer groups are paramount. I mean, they really need to know a lot of information regarding workers' compensation. But also you have your insurance agents. Insurance agents are critical because they're the ones that actually write coverage. You have attorneys and CPAs. They need the information because how many clients do they have? And unfortunately, workers' compensation is such a niche. You have so many different laws out there. And I'll give you an example for accountants. If you have an accountant and they know tax laws, well, then there's a definition of an employer under tax laws. Well, and an employee. Well, that's totally different than under workers' compensation, which is totally different than unemployment insurance, which is totally different than disability benefits insurance. They're confused. okay? And attorneys get confused. So that's the reason why we have to go out and talk to them. We also talk to government agencies, because when you're talking to, they have specific responsibilities under the workers' compensation law as well. So there's a whole core of individuals that really need to get this information, and we're certainly receptive to going out and meeting with people to try and get them the information they need.
Well, that kind of implies that the worker, him or herself, can kind of sail along and not know as much. And just keep working, and then somebody's going to help them out and tell them they have workers' comp. Is that pretty much true or not?
Well, yes and no. Hopefully, if the employers do their job correctly, one of the things is your employers have posting notices that they're required by law to put up on their board. And if you're an employer, you should have a form called the C-105, conspicuously posted on the walls, basically telling your employees, hi, this is workers' compensation, this is who your insurance carrier is, here's the phone number, and by the way, these are your rights under the workers' compensation law. If you're hurt on the job, this is exactly what you need to do. So, and that's the reason why it needs to be posted, so that the employees know this information. And unfortunately, or fortunately, there's now a $250 fine if the employers don't do that.
Okay. I know things disappear, though, not in terms of the sign's not there, but we tend to not see things after a while.
Right.
So I think it is great that you're on the show and you can just remind everybody that these things are there, maybe read them.
Exactly. And, and to know their rights. For those employees that are part of unions, et cetera, certainly their shop stewards can provide information regarding what happens when you're hurt on the job and things of that nature. But, one of the key things that we could do today as well is just at least tell people what some of the basic steps that they should do when they're hurt.
Before we get into the steps, workers' compensation and then benefits, you used that word. What benefits, what are they?
Well, you get unlimited medical care. And what do you mean by that? I mean, when I say unlimited, I mean exactly that. I've got one case where the guy's 32 years old, he's brain dead, intensive care for the rest of his life. Medical costs alone are actually estimated at over $2 million.
Wow.
If you have a workers' comp policy, your carrier is responsible for paying whatever it costs. And if you don't, you as a business owner are personally liable. Well, what do I mean by that? Well, if you are the president, secretary, and treasurer of a corporation, you are personally liable. And people say, well, geez, wait a second. That's why I hired an attorney to protect my personal assets. That's why I formed a corporation. Well, what workers' comp law is one of the only laws that pierces that corporate veil. So the president, secretary, treasurer is personally liable in addition to the corporation being liable. Naturally, if you're a sole proprietor or a partner of a partnership, you already know that you're liable for everything that legal entity is responsible for.
That that could take us in a number of directions.
Sure.
So there's the insurance part, which provides what I didn't even realize, excuse me, for paying for medical care, but I was thinking in terms of a check.
For the injured worker? Yeah, absolutely. One of the things with workers' compensation is it provides up to 2/3 of the person's average weekly wage up to the maximum allotted in law. Now, in terms of the current statute, that's up to $600 a week. Starting July 1st of next year, that benefit level for people that get injured on or after that date will be 2/3 of the state's average weekly wage, whatever that is, indexed for inflation, as determined by the Commissioner of Labor.
Now that's the maximum, 2/3 of that average.
So again, usually for most people it's going to be 2/3 of your average weekly wage. But again, because the maximum right now is set at $600, many individuals will be eligible for that benefit. But again, that's the time that you're not able to work in most cases.
Right.
Okay, so part of the workers' compensation program is to try and get people back to work as quickly as possible.
What is this 2/3? Where do you get that? Why do you do that?
Well, in terms of the 2/3, this was written in law, and part of the reason why it was put in there is because in terms of a person's gross wages, normally about 1/3 of that is based on your taxes, either federal, state, Social Security, et cetera. This is tax-free. So that's the reason why they went with the 2/3.
Okay. I guess it always concerns people if they get hurt or anything. And you mentioned insurance for medical. But why would the employer need this? What protects him?
Well, one of the key parts about why an employer, again, this is a process that protects both injured labor as well as the employers. In terms of the employer's benefit, they have the ability not to be sued. Workers' comp is the sole recourse of the injured worker against the employer in most cases. A couple of exceptions would be something called Dovidal. Dovidal is case law, and easiest way to explain it is back in the day, I used to work for General Motors. We used to have a Conrail freight train that went through our property. If I was ever working for GM and got whacked by that Conrail freight train, I couldn't sue General Motors, or my dependents couldn't sue General Motors. But what they could do is sue Conrail. Conrail would then countersue General Motors saying, hey, wait a second, you were supposed to erect safety crossings to protect your people. You didn't. One of them got whacked. We're being sued. We're countersuing you. Since the mid-1990s, that only applies in death cases, very serious accidents, so it's very rarely used. The one that's more common is the one that you hear on the 6 o'clock news, and a lot of newscasts. Different attorneys will come out and say, hey, if you're ever working and you're up on a scaffold or ladder and you fall out, give me a call. And the reason why they do that is because of Section 240, 241 of the labor law, the scaffold law. So again, that's one of the workarounds around the sole recourse of workers' compensation from an injured worker directly against their employer.
Now, is what they're trying to do determine if there's a grievous mistake on the employer's part? Maybe they don't have a safe working condition or something?
It could be in those situations, and that's where litigation can come into play. So, again, it's an additional employee benefit in terms of ensuring that there are safe workplaces for people when they're in especially hazardous situations.
Now, is there any way to protect people from a process going on too long if there's contention about who's responsible?
Certainly. Under the workers' compensation law, the reform legislation that went in 2007, one of the key benefits of that was to try and expedite the claims process for controverted claims. What happens...
And that's what we talked about the last time, I think.
It was.
Okay.
We were just starting to get into it, as a matter of fact. So what's happened since that time is there's been, there was the initial legislation, and now there's been rules and regulations that have basically implemented that legislation. Now, once we receive a controverted claim and we receive the associated medical, the board has 45 days to actually have start the hearing process, to actually get people together and to start finding out, okay, is there an employer-employee relationship? Was the person hurt while working on the job? What's the average weekly wage? All the questions that they normally have to ask.
And that's only in the unusual case.
Exactly. In most cases, people, once they're hurt on the job, they go to the doctor's office. They notify their employer immediately. One of the key things is, and this is something that the injured workers really need to know, if you're hurt on the job, naturally, if you're seriously hurt, immediately get medical care. If it's not, as serious an injury, let your supervisor know, let your coworkers know what happened, when, where. Many times it's witnessed, but especially in the case where, let's say, a person is alone on the job site and something happens, they immediately go and seek the medical care that they need, and then by law, they have to notify their employer within 30 days to make sure that their employer knows that, yes, they have been injured on the job, and then it's the employer's responsibility. If the person, is lost time, and if they have received more than 2 times of medical care, they need to report it to the Workers' Compensation Board.
We're kind of into the process here, so why don't we just keep going with that?
Okay.
We can come back with some of my other questions. Let's take it right through the process.
Okay.
We don't have to put them on a ladder, but whatever.
Sure.
Somebody's working, and they get hurt, however.
Usually what happens is, once you're hurt, first of all, in terms of what's a claim, because again, unfortunately, once you get into the workers' compensation law, you get into all this legalese and all these terms. So we'll start off with the basics. What's a claim? A claim is very simply the process by which, first of all, the injured worker notifies the employer that, hey, I'm hurt.
Could be verbal.
It can be in certain cases. It's always best to be in writing. Okay. The other part is there's a process where the injured worker can notify the Workers' Compensation Board. If the injured worker has more than 2 visits in terms of medical care, and if they've lost time on the job, then they should be filing, or they can certainly file a form called a C3 to protect their rights. So Well, the key thing is, again, if they do it, they should file that C3 within 30 days. But again, that's the same thing that they should do in terms of reporting their injury to their to the worker or to their employer.
And if we went back to an employee lounge or something in that poster, there's probably a phone number.
They should have on each of the forms, basically all the carriers have been notified. They have to update them annually, so this way people know who their current insurance carrier is. But they should have the name and address of the insurance carrier, and they should have the phone number where they can contact them.
Okay, so they don't call you, they call...
They could, again, they can file the form, the C3, with the board. That's with the injured worker's notification to the board that there is a claim. The employer, in the meantime, has responsibilities. Under the law, as soon as there's an accident that occurs, they have to keep records of everything. But in terms of notifying the board, if there's lost time and if there's more than 2 visits for the doctor, example, when I used to work for General Motors, I got whacked on the head. I ended up getting stitches. The employer had to keep a record of my medical care because, again, I had to go in and get the stitches in, get the stitches out. But, I went back to work the same day. So, it was something where they had to keep a record of it, but they never had to notify the Workers' Compensation Board.
And it sounds like maybe you would recommend to an injured worker that they also keep their records together of everything that happens.
Absolutely. And it's the same thing for the employer and the injured workers. Again, they should keep their records in terms of the medical care, et cetera. They, should document, when they had to go for the health provider, et cetera. Naturally, your health providers are going to be submitting information to the carriers because they want to get reimbursed for the costs that they have, for the services that they provided. And that's their recourse.
Okay. So is there any checks and balances to make sure all the steps are followed?
Certainly. What happens is when a person gets injured, and let's say their claim is filed with the Workers' Compensation Board, then it's up to the Workers' Compensation Board to go through the process to make sure that everything is correct. They go through the carriers as well. The carriers file the paper. Maybe we could talk a little bit about some of the players in the system, because again, everyone thinks that the Workers' Comp Board is in charge of everything.
Well, I was a little confused about that too, because that's what I thought.
Mm-hmm. We do 2 main things at the Workers' Compensation Board. We basically process the claims, and then we also make sure every employer in the state that's supposed to have coverage actually has it. Some of the other players in the system, the insurance department, they make sure that the carriers have enough financial resources to actually pay the claims, and they license all the carriers in the state that are able to write workers' compensation. They're also involved right now in writing a lot of the rules and regulations regarding that. In terms of some of the other players, you've got the Compensation Insurance Rating Board. They do 2 main functions for for workers' compensation. They basically set all the underwriting rules, and they set the rates. Now, how do they set the rates? They basically take a look at all the different industries in the state. They class them out according to industries. Are you involved in agriculture, or are you involved in manufacturing? Are you involved in transportation, trucking, et cetera? Or are you in construction? Oh, you're in construction. Then they break it out further. Well, are you an electrician or are you a plumber? Are you a carpenter? Each one has different rates because each one has more or less injuries depending on how hazardous it is.
Right.
Then on top of that, they do something called an experience mod. And that is, okay, you're a plumber. How is your rate of accidents compared to other plumbers? Do you have more or less accidents compared to your payroll to other people of similar size, et cetera? So they break it all out. And it's similar to your car insurance policy. Example, if you're a good driver and you live up in the Adirondacks, you've never had a speeding ticket or an accident, you get discounts and low rates. If you live in Manhattan and you've had a ton of speeding tickets and accidents, guess what? Your insurance carrier surcharges you.
And even if you haven't, there are so many accidents taking place, there's a bigger chance you'll have one too.
Exactly. Mm-hmm. And it parallels very nicely to the workers' comp system for that.
So we've got the players. Anybody else in there that we left out?
Well, in terms of that, you've also, naturally, as I said, the big player is going to be your insurance carriers. Okay, it could be the employer self-insured. They're a huge organization, and they basically self-insure. But it's big money to be self-insured. These are your huge corporations or your municipalities that are going to be self-insured. In most cases, people are either insured through a private insurance carrier or they're insured through the state insurance fund. The State Fund is a public carrier. They are the insurer of last resort, and by law, they're supposed to provide insurance at the lowest possible cost. They have to write you, but on the other side, they have a lot of good risks too. But one of the key things is for this state insurance fund, usually what I tell employers to do is shop around. Workers' comp is a competitive industry in New York State. Check with, the employer that does, or your insurance carrier that does your liability insurance. They may be able to write your workers' compensation, or check with your trade association. They may be able to recommend different carriers that write your particular industry. And, if no one else will write you, the state fund has to.
Okay. And from the worker's point of view, all that takes place
behind the scenes.
Behind the scenes.
Yeah, hopefully a worker, in most cases, hopefully most people will never have to know about the workers' comp system because, they're never hurt. The best accident is one that never happens.
Of course, yeah.
So, but, God forbid something does happen to somebody, that's why the workers' compensation system is here. It's the safety net that is set up to protect that injured worker, to make sure that they get the medical benefits they need to get them back as quickly as possible, and also to at least provide, some remuneration for lost wages until they're able to return to the workplace.
Now, until they are able, is there a limit?
It depends on the type of injury. For certain types of cases, example, in death claims, permanent total disability, it is still unlimited duration. One of the first claims we ever had was a bridge painter who fell to his death the day the law became effective in 1914. And his widow started collecting death benefits in 1914, continued collecting them until the mid-1990s. So it's a long time for receiving benefits. Many states put caps on all different types of benefits, but New York, for death claims, permanent total disability, it could be unlimited duration. For permanent partial disability, the 2007 reform legislation did put caps on that up to approximately 10 years for people who are severely injured. There is a safety net on that. If you're more than 80% disabled and you are injured on the job, what happens is if at the end of that duration of time you are still unable to get back into the workplace, you can basically file a hardship with the Commissioner of Labor, and then they can extend benefits.
Okay, so there would be that step only if it comes into play with the worker.
Exactly. Hopefully, for most employees, they're going to be, their injury will, basically run a course, and then after that, they can either be retrained or, somehow get back into the workplace and earn as much or more than what they were earning prior to the injury.
Now, is there any kind of thing protecting the system from people who just don't get better on purpose?
Are you talking about fraud?
Yes, yes.
Everyone thinks that when you're talking about workers' comp fraud, it's purely the claimants. And, very honestly, we have had this situation with injured workers where certainly they have filed benefits fraudulently. And, there's a system of checks and balances against that. The carriers are supposed to be monitoring this. Certainly, employers can be providing information to their carriers so that this way carriers can controvert claims and basically say, hey, this person is well enough to return to the work site, et cetera. This is what they were doing.
So they'd be forced to go to a doctor or something?
Absolutely. The board can require individuals to go through, to basically have medical exams at any point in time if we feel it's necessary.
And that would be, would it be the patient's doctor, or could they be required to go to an outside doctor?
The claimant's
or a second
doctor,
opinion or something.
The claimant's doctor can render an opinion. The carrier's doctor will render opinion. The board can also have impartial specialists that we basically retrain also to retain. If we're not sure which one is accurate, et cetera, we can get a third medical opinion, and then it's up to a workers' comp law judge to take a look at the facts of the case and then render a decision based on his or her best opinion.
Now, it seems unlikely that a business wouldn't have workers' comp, but I think it was mentioned if they do, or to make sure they do. So how often does it happen that somebody doesn't, or a company doesn't?
It certainly does occur, okay, and that's part of the reason why the Bureau of Compliance is, and fortunately the law in 2007 basically gave the Workers' Compensation Board the teeth now to ensure that employers actually have the coverage in place. The penalty has been, is now $2,000 for each 10 days that an employer doesn't have coverage. That's $72,000 a year base penalty. That's the civil penalty. penalty. In addition, if an employer has 6 or more people without having workers' comp, that's a felony. The workers'
That means jail.
It certainly could be.
Okay.
And the Workers' Compensation Board periodically does sweeps. We go out and check with employers to make sure that they've got the coverage, and if they don't, we can shut them down.
So if any company told an individual that they're self-insured or something, this would be not true.
Well, they could be self-insured if they're a big corporation. They could have something called group self-insurance if they are part of a trade association, et cetera. There are specific groups which are authorized under the workers' compensation law. If people are unsure whether or not their employer has workers' compensation, easiest thing to do is to check our website. We're going to give everyone the website at the end, but right on our website, on the homepage of our website, at the lower center, there's a nice blue question mark, and it says, does an employer have coverage?
Okay.
They can click on that, they can put in their employer's name, and they'll be able to see immediately if their employer has coverage or not. If they think their employer doesn't have coverage, they're right associated on that. There's a whistleblower form.
I was going to wonder if it's private,
Yeah, and it could be certainly confidential, but they can send us a note and electronically, or they can certainly pick up the phone. Again, we're going to give out phone numbers at the end, but this is ways that people could notify us that hey, the employer either doesn't have coverage, or they're misclassifying individuals. They're saying everybody's an independent contractor when they're really employees, or they can go through and they could say, hey, they're misrepresenting their payroll. They're paying everybody off the books, under the table. They're hiring all illegal aliens.
Rates or something, and that would. The advantage there would be they would pay lower rates or something.
Absolutely.
Okay.
And so what happens is, this is part of the workers' compensation fraud. That's part of the workers' comp law. It's something where if an injured worker basically comes in with fraud, they basically have to the Workers' Comp Board does have a fraud investigation unit, and we will prosecute that. On the other side, if you've got an employer that is doing any of those things, we're going to go after the employer to make sure that that employer has represented their payroll properly. If they haven't, guess what? It's a felony in many cases. Okay, they've lied to the insurance carrier. They've falsely documented. There's also penalties associated with that. That's the same as not having workers' compensation insurance. So there's stiff penalties there, but they're not the only ones that can commit fraud. It could even be the doctors, saying and basically filing for services that they have never provided. It could be the insurance carriers doing certain things. So it doesn't matter who it is in the system that's committing fraud. That hurts every legitimate business in the state of New York.
And that's why it's important to keep
Absolutely.
things working
We need a
properly.
level business playing field in the state.
I think we covered, let's make sure we did. Are there any other steps that the person might be required to take that we didn't mention? Okay, they're going along, they're inscribed, they're getting their check and their health insurance. Any reporting things or?
Basically, the injured worker is going to, in certain cases, the case is going to go along periodically. Your carrier may require additional medical examinations, et cetera, to make sure the person is still totally disabled.
So expect that.
Absolutely. And from an injured worker standpoint, that is something that they should be able to, expect, and that's part of the system. Because again, the system has to ensure that the claims are legitimate.
And I would think most people want to get back to work. It's not that everybody wants to stay home.
Absolutely. And as a matter of fact, the board now, through the, again, 2007 reform legislation, there is now a return to work program as well.
I wanted to ask you about that.
Yes, it's something that under the statute, it is primarily going to be initially geared as a requirement for those employers that have over $800,000 worth of payroll, which again is a larger employer, and they also have to have over a 1.2 mod for their experience mod, which means they've got about 20% more accidents than most businesses.
Okay. And that's an either or?
No, it's both.
Both,
They have to hit both of those to be absolutely required. However, we're going to be looking to get a lot of large businesses to voluntarily start this program. There are going to be certain benefits to doing it financially for them, because they can experience reduced reduced premiums, but in addition, their experience mods will be decreased by getting good safety programs, by having return to work programs in place, getting people back to the workplace as quickly as they're medically able to do it. Example, somebody has a hernia. They're normally lifting heavy things as part of their job. As part of that, normally, they're not going to be able to immediately return to the job and start doing the heavy lifting. However, the employer could have a light duty assignment for them, which is something the employer may not. Every employer, especially a large employer, has stuff that they want done. But in certain cases, when they bring back an experienced worker, they can't go back to their regular job right away. But within 3 months, they may be able to. So the first thing is get the person at home, have the employer, the supervisor, et cetera, contact the injured worker. Make sure they feel like they're needed, that the employer really cares about them.
That's a nice step.
It certainly is. You know, this is something that benefits injured labor and the employer, both sides. This is, you know, everyone thinks that it's got to be a combative type of thing. This isn't. We're human beings. Human beings help each other out. And as part of this, your injured worker, you know, can certainly want to get back to the workplace as quickly as possible. The longer they're away from the workplace, not only the more medically disabled they feel that they are, the mental comes in. Then they really start thinking, oh, geez, this is really bothering me. And this is just a psychological thing. So to get the employer back into the structure of the workplace as quickly as possible, this is wonderful for business and for the injured worker. They get back in the workplace and they're able to be a productive member of society again. From an injured worker, they're also receiving their wages again, and they start accruing vacation time. They start continuing to accrue towards their retirement, et cetera. So it's a good benefit for both sides.
I guess one more thing, we're about out of time.
Mm-hmm.
I think we've covered pretty much what we
sure
wanted
did.
to cover. In terms of injuries, it seems like pretty much any injury is covered. Are there any exceptions?
In most cases, if you're hurt on the job, if you're listed as an employee under the workers' compensation law, you are most likely going to be covered.
But psychological issues?
It can be.
Can be?
Yes, it could. Okay. You know, in many cases, because you know, those will most likely have to go through a hearing process, et cetera, because you know they're going to need to take a look at the documentation. Was it a work-related type of issue, and or not? The other part of it is in terms of occupational disease. In many cases, some injuries, you know, everybody's aware of. Geez, you got hurt at work, you broke your arm.
Right.
Okay. Easy cause and effect.
Nobody's going to doubt that.
No, but what happens for long-term disabilities? Things like
Repetitive stress or
asbestosis, and things like this. You know, where it's going to take up to 18 years before you're even subject. You know, where you're even going to start receiving those symptoms. In those type of cases, what the workers' comp law requires is that the injured worker report the claim to both the employer and to the workers' compensation board within 2 years of the date of their knowledge that it was most likely. It was work-related. Well, again, giving them, because again, for those type of things, you know, you may start receiving, you know, knowing that you're having difficulty breathing, things like that.
And you deny it probably yourself for
absolutely, and it's going to take a little bit of time before you get the medical results in to say, hey, by the way, you've got this, and this is definitely job-related. Okay. So then there's a process related to that.
Now, the last thing, and we really don't want to leave that out because people may have questions that we didn't think to answer.
Absolutely.
How do they reach you?
Okay. Hopefully, there's a number of different ways.
We'll put all this on the screen.
Okay. Right now, on the easiest way to know what's going on in the workers' compensation system is take a look at our website. The website right now is a wealth of information. It will guide people through as an injured worker and as an employer. For those of you that are employers that are viewers, if you take a look on the Workers' Comp Board website, click under Employers and click under Employer's Handbook, and it'll give you a wealth of information as to who needs to be covered, who's exempt, and go through the entire process on that.
And that can't hurt to know more about this.
Absolutely. You know, information is key. If you have questions, because even after reading information, people are going to have questions. Call us, okay? In terms of claims questions, the number is on the screen. It's 866-396-8314. For compliance questions, those are specifically for employers. Contact us at 866-298-7830. And for those employers who somehow get caught in the workers' compensation process with very complex questions, give our advocate for business a call. His name is Neil Gilberg. He'll work with you and try to come up with answers just in case there are really difficult issues that you're faced with. His number is 800-628-3331.
And if he changed, it would still be Advocate for Business.
It would
at
still
the
be
same
the
number.
advocate for business, absolutely.
Okay. Well, I know there are other questions we could go into, but I think we've given people a lot to
We've covered a lot of ground.
Right, covered a lot of ground. It's always a nice thing to talk to you, but it is a difficult topic, and it's nice to learn something, too.
It's a pleasure. Thank you so much.
Thank you, Steve.
Okay, Richard.
I want to thank Steve Carbone from the Workers' Compensation Board, and I want to hope that you all have a great week and that you tune in again next time. Take care.
Welcome to Channel 17, the Town of Colonie Government Channel.